What happens once the European Account Preservation Order is granted? The European Account Preservation Order procedure contains a number of innovative features. Apart from the ex parte nature of the original application procedure, the enforcement of the order has to take place without delay and with the maximum of efficiency. The procedure is the first whereby the EU provides directly for the execution of judgments, and the key features of the European Account Preservation Order are therefore of considerable significance. The form of the order. The European Account Preservation Order is to be issued in a standard prescribed form, which is to be in two parts and containing the information set out in the regulation. Any funds remain preserved so long as the order is in force and subject to any modification, limitation, revocation, termination of the order, or enforcement of the liability in respect of which it was granted. The order is to be enforced without delay, in accordance with the rules applicable for equivalent orders in the member state concerned. No declaration of enforceability is required. Transmission to the bank. The order is to be transmitted to the bank or banks concerned, along with a blank form of declaration to be completed by the banks. The transmission procedure depends on whether the order is to be enforced in the same member state as the court which granted it, or in another member state. In the former case, the transmission is effected according to the procedural law of the member state concerned. In the latter case, the order will be transmitted to the competent authority of the member state of enforcement, if necessary, accompanied by a translation into an appropriate official language of that state. Response of the bank. Any bank to which a European Account Preservation Order is addressed has to implement it without delay. The bank has to preserve the amount specified in the order by ensuring that it is not transferred or withdrawn except to a special preservation account. Within 3 days of the implementation of the order, the bank sends the declaration of preservation of funds to the creditor, or, where the order was issued in a member state other than that of enforcement, to the competent authority in the relevant member state, which in turn sends it to the creditor. Service on the debtor. Thereafter, the order is served on the debtor with the declaration, the application, and accompanying documents either by the creditor or by the competent authority of the state of enforcement. Where the debtor is domiciled in another member state than that where the order was issued, service is effected within 3 working days after receipt of the declaration from the bank. The documents to be served are transmitted to the competent authority in the member state of the debtor's domicile, and that authority then serves them on the debtor in accordance with the law of that member state. Where the debtor is domiciled in a third state, the documents are served in accordance with the rules on international service applicable in the member state where the orders was issued. Remedies and other provisions for protection of the debtor's interests. Since the European Account Preservation Order is issued without the debtor being heard, the regulation grants the debtor a variety of remedies against the preservation order itself or its enforcement. The remedies available to the debtor are, in addition to the conditions for issuing the order and the liability of the creditor for any breach of those, a key element in the regulation to strike a balance between the creditors and the debtor's interests. The debtor can request a review of the preservation order, notably if the conditions for issue set out in the regulation were not met, for example, because the issuing court did not have jurisdiction, or because the creditor's claim did not exist or existed only in a lower amount, or because the creditor's claim was not in urgent need of protection in the form of a European Account Preservation Order. The debtor can also request a review if the circumstances that led to the issuing of the order have changed in such a way that the order would no longer be justified. For example, because the claim has been paid in the meantime. A remedy is also available if the order has not been properly served on the debtor, or if the documents have not been translated into a language they understand or into the language of the member state where they reside, and these defects of service have not been cured within a specified time period. A form for use in applying for the various remedies is to be prescribed by the Commission. An appeal is available against any decision as regards the remedies provided in the regulation. The debtor may also apply for release of the funds on provision to the court, which issued the order of sufficient security or assurance under the national law of the court. The regulation also contains a number of additional provisions protecting the debtor's interests. Thus, certain amounts can be excluded from the implementation of the order where these are exempted from seizure under the law of the member state of enforcement, whether at the request of the debtor or otherwise according to that law. These will include amounts needed for the maintenance of the debtor and their dependents. In addition, the creditor is liable for any damage caused to the debtor by the preservation order due to fault on the creditor's part. The fault is presumed in certain situations. Finally, the creditor is bound to request the release of any funds above the amount specified in the order where several accounts have been preserved by European Account Preservation Order or by an equivalent national order.